what this investigation may end up being is about the essentially the falsifying business records, which, by the way, this prosecutor has brought over 60, this one and the previous one brought over 60 times over the last 4 years. This is not an unusual crime to charge somebody with in the Manhattan District Attorney's Office. We have over 60 instances.
Chuck,
here,
you couldn't be more wrong. You couldn't be more wrong when you make that statement. This, first of all, would be a case of first impression. Never in the history of this country has this been done before, and never in the Manhattan District Attorney's Office has someone been charged with a crime for falsifying business records to pay hush money, as they call it, or it's a confidential settlement in legal jargon, regarding a personal matter. Never in the history of the Manhattan District Attorney's Office. If there were a filing obligation, if he had taken a tax deduction, which he did not, that would be a crime. If he had used campaign funds, we'd have an argument here. This was a personal matter,
but he called it legal funds. They called it legal fees. They claimed it was to pay a legal retainer.
In fact, they were in. No, it didn't say legal retainer. It was legal fees that was invoiced by Michael Cohen, who arranged this on his own with his own money initially, took out a loan, literally, resolved this without the president knowing, came back and then sent a bill in for 4 times the amount. Over the course of a year, it was paid off as legal fees, as was the invoice. But what would he supposed to put in his personal ledger? Seriously, what would he put in his personal ledger? Payment for hush money to quiet an affair that I claim I never had, so my family doesn't get embarrassed. Is that what he should put in his ledger? If there's nothing wrong with whatever you want your ledger.
You keep saying what should be in the ledger?
Chuck.
Should it be the truth?
Chuck. Would you ever put a 4-paragraph sentence into a ledger? Chuck, you're being, honestly, I think you're being a little petty when you're looking at this now, because there is no filing obligation. You can put whatever you want in your own personal ledger. If there were a tax obligation, that would be one thing. If he had taken campaign funds, that would be something else. Neither of these things happened here. So you have a situation where you're looking at either, was it a tax deduction? And they pulled it out of the grand jury because they thought initially he was taking a deduction. He did not. And secondly, did he use campaign funds? If he did not, he used personal funds. And the test, again, is would he have made that payment regardless of the campaign? And the answer to that question is a resounding yes, by all accounts.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.